Right to shelter is a basic human right, and especially for a woman to be put out of the house invites her with untold miseries and dangers. Since early days, it's been very easy to overpower a woman and then simply push her out of the house, but not anymore. Now, a woman not only has a right to reside, but she can also stop the abuser from entering his own house. Watch this video to know the legal expanse of a woman's right to residence as provided under the Protection of Women from Domestic Violence Act. Hi, this is Advocate Alisha Dijresh Phalga, and this is my channel where I'll be telling you all you need to know about the laws that matter. The patriarchal society we live in has put men in a position of dominance, including in matters of owning properties. In this scenario, a woman became increasingly dependent upon her male relative or the husband to provide her with shelter, which is so necessary for protecting herself and her modesty. This dependence became a powerful weapon in the hands of the abuser to silence her protests against domestic violence meted out to her. And if threats didn't work, then a woman could simply be pushed out of the house by force or some clever device. In order to address such instances of harassment, the Protection of Women from Domestic Violence Act has given a statutory recognition to this basic human right under Section 17 of the Act, which now affords to every woman in a domestic relationship the right to reside in the shared household and further guarantees that she shall not be evicted or excluded from the shared household or any part of it by the respondent, save in accordance with the procedure established by law. Therefore, no longer can a woman be thrown out of the house by force or some clever device. If she has to be, then it will have to be by due process of the court. Now, you may have noticed me use the term shared household quite often. This is because the Act has used this term to denote the house where the aggrieved woman lived or presently lives with the abuser in a domestic relationship. The definition takes within its sweep a situation where the woman lives in the house alone or with a respondent, presently or in the past. The definition then also provides for cases where the house may be owned or tenanted, such as a place taken on lease. The house may be owned by the respondent by himself or jointly owned by the woman and the respondent. The concluding part of the definition states that a shared household includes a household which may belong to the joint family of which the respondent is a member, irrespective of whether the respondent or the aggrieved person has any right, title, or interest in the shared household. Thus, it is now clear that it is not necessary for a woman to have any right, title, or interest in the house. And if the house is owned by the husband, then a woman can obviously claim her right to residence in that house. But then, what about a case if the house is not owned by the husband but by his family members or his parents? Would a woman still have her right to get the right to residence enforced in terms of such a house? The view taken by the Honorable Supreme Court in the case of S.R. Batra vs. Taruna Batra, which was decided in the year 2007, was that the wife is entitled only to claim a right to residence in a shared household, and that a shared household would only mean the house belonging to or taken on rent by the husband, or the house which belongs to the joint family of which the husband is a member. In this case, the house was owned by the mother-in-law and not by the husband. The Honorable Supreme Court held that the aggrieved woman, being the daughter-in-law, could not claim a right to live in the house owned by the mother-in-law. The Supreme Court also held that an aggrieved woman can claim a right to alternate accommodation only from the husband and not from his parents or siblings. However, in a very recent judgment delivered by the Supreme Court on the 13th of October 2020, the Honorable Supreme Court has overruled its earlier Taruna Batra judgment. Now the court has held that an aggrieved woman can claim a right to reside not only in the house owned by the husband, but also in a house owned by his parents or family members if she was residing there in a domestic relationship. A woman can enforce this right to residence by securing a residence order which can be applied for under Section 19 of the Act. A residence order in simple terms is a court order which the woman can apply for to secure her residence in the shared household. Upon being satisfied that domestic violence has taken place, the magistrate can pass an order restraining the respondent from dispossessing the woman from the house or in any manner disrupting or disturbing her possession of the house. In an appropriate case, the magistrate can also direct the respondent to remove himself out of the house, except if the respondent is a woman. If the respondent is a woman, then the magistrate cannot direct the respondent to remove herself from the house. The magistrate can also restrain the respondent or any of his relatives from entering any portion of the house where the aggrieved woman resides. If the aggrieved woman apprehends that the respondent may sell, lease, or mortgage the house, the magistrate can pass an order restraining the respondent from doing any such acts of alienating, disposing, or encumbering the property. The magistrate can also pass an order restraining the respondent from renouncing his rights or giving up his rights in the house. Another very important and valuable right given to a woman under Section 19 is that she can claim an alternate accommodation from the respondent. In such a scenario, the magistrate can direct the respondent to provide an alternate accommodation to the woman of the same level that she was enjoying previously in the house. The respondent can also be directed to pay rent towards such alternate accommodation. Now, this is a very important right because in many cases, a woman may not feel safe to stay in the house where the abusers are living and have tortured her. In such a scenario, she can opt to obtain an alternate accommodation of the same level that she had been previously enjoying. Under Section 19, the magistrate is also empowered to pass any such orders, directions, or impose any conditions which are necessary for the safety of the woman and the child. An important aspect is the magistrate can direct the police to provide protection to the woman and to assist her in implementing any of these residence orders. With this, we cover the essentials on the right to residence and residence orders as provided under this Act. Another very important right given to women under this Act is that she is entitled to monetary reliefs from the respondent. And that is the topic I will be covering in my next video. So make sure you hit the like, share, subscribe and bell icon button so you don't miss out on any of my videos. See you soon.